This directions hearings in the matter of case number CF 5061-2022 before the Registrar Ayesha BinKalban. The claimant is represented by Curtis Malley Prevost Colton Mosul LLP. Lead counsel is Mr. David McCarthy, and the defendant is represented by Dooman Partners, and the lead counsel is Mr. Edward Selwan.
All right, thank you for being here, gentlemen. Do we have any agreement on who would like to go first?
Not yet, madam. I'm happy to go first, given that
Go ahead, Mr. McCarthy.
for the claimants.
Yeah.
Yeah, obviously you've received the Skellington. I'm mindful that there's quite a bit of documents that were filed on Monday and last week. So what I thought I'd do is it might be helpful just to go through I think are the sort of the key events, so you're aware of the sort of timeline of what occurred, because I know that obviously your previous colleague Miss Hanaido was on it, and she's well aware of it, but I understand she's no longer with the court. So I thought maybe it would be a bit better just to go over sort of the key events and then the key issues, or what we say the issues are on this matter.
You don't need to worry about taking me too far
Okay.
into the background. I've done some reading, so I think I'm well aware on the facts, but a brief summary would be okay.
Yeah, okay. If I can take you just to on the bundle HB1, that's obviously the order that was made by Sir Justice Jeremy Cook. So that put the company into liquidation and appointed our client, or not our client, appointed the liquidator, Mr. Gupta, as the liquidator of the company. Then at exhibit HB129, we have the creditors report. So essentially, this is a list of all the creditors of the company. You will see that the defendant is listed on there, but there are also other creditors. I think it's around about 49 creditors of the company. And then if I can just take you to HB133, and these are the assets essentially that are sort of become a sort of a point of discussion on the matter. There's a sort of an inventory list of what these assets are, and then you have sort of at the front page of that document a value of approximately 710,000 dirham. Just going back to the previous exhibit HB129, you will see that the debts of the company in 2020 were 1.28 million dirhams. So the 710k is obviously a big point of contention, because obviously it takes up nearly 70 to 80% of the debts that are owed by the company to the creditors. And in 2020 to 2022, we've had these proceedings that the defendant as claimant has issued. The issue, I think this is a sort of a key issue here, is that our view or our position on the issue is that the claim itself brought in 2020 concerned essentially a creditor claim by the defendant. It didn't concern the assets at that point in time. They were a talking point of the proceedings, but essentially the facts of that, or the issues in that dispute was whether the claimant had a claim against or a debt owed against the liquidated company. We obviously, or our client obviously disputed that, and then we went down a route of a Part 8 claim towards a Part 7 claim. And now we have in 2022, we have these new proceedings. Our client's position essentially is that they're different. They're different on the basis that we're not discussing or we're not disputing here, or we are disputing. The dispute isn't around the creditor claim as such by the defendant. The issue is on the assets themselves, and we say, or our client says on that point, is that the assets are held or are currently held by the defendant. Those assets make up a significant portion of the liquidated company, that being around 70 to 80% of what the assets it currently holds. Moreover, the other issue is whether, well, essentially the assets in dispute are held by the defendant. That's the issue. There's no dispute around that fact. The other issue is that the assets are the assets of the liquidated company. We've spent, or the liquidator has to spend the last 2 years disputing these proceedings brought by the claimant, and we're at a position now 2 years into the liquidation where the liquidator has been unable to wind up the company. It's been unable to pay any of the creditors. It's had to fork out or had to take on risk of defending proceedings by the claimant or the defendant at that time, and we've initiated these proceedings on the basis that the claimant needs to, or the defendant needs to, either reimburse our client for the value of the assets being $710,000, or return them as such. But our issue around the returning of the assets that you will see is that it's been 2 years since the assets were in the possession or have been disposed of by the defendant. At that point, I think that's all I have to say on that. The only other issue that we have to have, that I would like to say, is on the disposal, that being the witness statement of Mr. Kabusi. You will see in his statement he makes a number of statements, namely around the disposal of the assets. Our position on that is if it's given to a third party, that in itself is a disposal. It's been used for the last 2 years, and I think the defendant solicitor needs to be mindful of that, not to mislead the court. A disposal is a disposal. If it's given to the third party and the assets are that of the claimant, that is its disposal itself. For the time being, I think that's all we have to say on those points.
Thank you, Mr. McCarthy. Would you like to go ahead, Mr. Savalan?
Yes, thank you, Madam Registrar. First of all, with regards to the last statement of Mr. McCarthy regarding misleading the court, actually what we did is the exact opposite. Mr. Kabusi, in his witness statement, just wanted to confirm that these assets are still located in the premises. On that note, the defendant is not arguing the opposite, and being mindful that when we use a term like disposal, liquidated, sold, at some point the defendant needs to confirm their position with regards to the contention of the claimants in the present proceedings. So accordingly, that statement was made to confirm a fact that these assets are still located in the premises. On that note, this is basically the whole issue of these proceedings on Part 8. First of all, the main topic that was argued in CFI 059/2021 is actually the assets. Now, the legal consequences, or as a result of which these assets are still located as of today, is a matter to be in the defendant's position to be decided by a Part 7 judge, as there is a substantial dispute of fact. In line of the doctrine of res judicata that we have argued in our skeleton argument, the fact that in CFI 059, former Madam Registrar has confirmed that this course of proceedings, that particular claim relating to the same parties, the same case, is heavily disputed and disqualified in her order, Part 8, and progressed the claimant to Part 7, is a direct precedent that could be argued with respect to that particular case. This particular case has been already litigated twice within the course of the year. We're dealing with the same parties, the same assets, the same subject matter, which is the lease agreement that, sorry for the term, went south between two parties and their related parties. Accordingly, the sole properties in this particular matter, if the claimant would have standing to a claim if and only if they could progress a claim before the DIFC courts, our position is simple. Let's go for a Part 7. We would have the benefit to have a CMC, an agreed or disagreed list of issues, a standard production of documents, have the benefit of part 28, maybe an expert, maybe we could counterclaim. So this matter being litigated twice within a year is, in the defendant's position, a proof that the facts are not concordant. We are in dispute. We are in dispute of the facts, and we are in dispute of the facts on the assets, which are the main topic litigated twice. This is the main argument of the defendant. And the witness statement of Mr. Kubaisi is meant to shed some light on what is the exact dispute on this matter, and it's not the alleged disposal, alleged liquidation, alleged sale of these assets. On that note, this is our main argument, to respectfully submit to the court that if and only if the liquidated company would have standing before the DIFC courts, we should respectfully submit that this matter be progressed through a Part 7 proceedings in line with the previous decision of former Madam Registrar Noor Al-Inaidi. Thank you.
Thank you very much. Would you like to respond, Mr. McCarthy?
Yes, just to go back on the issue of the assets in position. I don't want to get too delved into this, but I think we need to make it clear on that point. The assets are in possession. They're obviously at the defendant's premises. They're being used by a third party, that being the tenants. They're not being used. Or they're being used by a third party. They're in their premises. It's obviously been disposed of. I think we need to make that point clear. The other point on, I think the issue is this the same sort of proceedings on the to the first proceedings issue? Our position on that, it is not. This is purely, the first set of proceedings was a creditor claim essentially made against sold properties against a liquidated company. That's what those proceedings were. That's what those proceedings concern. The proceedings here are about the assets of the company. There is no dispute that the assets of the company are currently with or have been disposed of by the defendant. Our client's at a position now, it's a liquidated company. It's over 2 years now that it has 48 other creditors that have waited for the company to be wound up. It cannot be wound up until the assets are converted into dividends to pay out to the creditors. If these proceedings would go down Part 7 route, the creditor is now looking at 2 to 3 years of delays to get its hands on the assets. It's not only the creditor or the liquidated company that has been prejudiced here. You have 49 other creditors who have waited 2 years. 2 years they've waited to get the assets or get their payouts of dividends so that the company can be wound up. The liquidator has an obligation by court order of Sir Jeremy Cook in 2020 to wind up the company. He's been prevented from doing that from these sets of proceedings, from first of all the first sets of proceedings, and now he's had to initiate the second set of proceedings in order to get his assets back for the company, for the benefit of the creditors. This isn't for the benefit of the liquidated company, it is for the creditors. If our client is faced with another Part 7 proceedings, it will further delay the proceedings, and we're looking at 2 to 3 years until this company is wound up. I think the prejudice that was caused is significant, and our position on that is that this should go down a Part 8 route. If not down a Part 8 route, it should a consideration to be given to an immediate judgment application, which our client is currently considering.
Mr. McCarthy, just a quick question. Your claim contains a claim for interest?
Correct.
And is your position that that could be an assessment on interest can be done by way of a Part 8 claim?
Correct. Yes.
Mr. Sanwan, do you have anything to respond to briefly, since we have a lot of time left?
Yes, thank you, Madam Registrar. Whilst I am mindful that the company is currently in liquidation, however, we do need to bear in mind that we are also referring to a defendant who has also been prejudiced from not being paid any rent from the beginning of the execution of the lease agreement. Now, I'm not here to re-argue the case that was argued in CFI 059. However, and I would not do that because it's not the topic of this proceedings. However, the factual context, the factual background relating to the assets, the behavior of both parties within the course of the liquidation, the decision of the liquidator, why these assets are still located in premises, this is heavily disputed. This is meant for a Part 7 case. It's meant for being litigated in a Part 7 case where both parties can submit their arguments in order for instance, the defendant to submit a comprehensive statement of defense, perhaps counterclaim, if they have a counterclaim, a standing for a counterclaim. There is a direct precedent on this, Your Honor, and it's meant to be litigated in a Part 7 claim.
I think it differs. I think it doesn't cause prejudice to the defendant. If the defendant was given leave to bring a claim under Part 7, it chose not to. That avenue is still open. If it wishes to bring the claim against the liquidated company, then it should do so under a Part 7 claim. It's not prejudice if these proceedings go down a Part 8 claim. It has to be differed here that we have a claim for assets here, and assets which isn't disputed. The issue on their claim, when they say that they're prejudiced, is that it's essentially a creditor claim. They've been given leave to bring that claim. They chose not to. They can still bring that claim if they wish to and file it down a Part 7 avenue. That's a completely separate proceedings. These proceedings primarily concern the assets of the company. Assets which have been withheld from our client for the last 2 years, and we have 49 creditors waiting to be paid out and the company to be wound up. The liquidator's obligation has to fulfill under the insolvency laws, which it hasn't been able to fulfill because of these proceedings, being the first set of proceedings. I think the issue of whether a use by a third party is disposal is primarily a question of law.
I'm inclined to agree, Mr. McCarthy. Mr. Sanwan, I mean, at the end of the day, I don't see any prejudice by this claim proceeding down a Part 8 claim. I don't see any substantial dispute of fact that cannot be aired out by way of a Part 8 claim. I mean, unless you can tell me exactly, without skirting around the issue, what exactly the facts are that are going to be disputed in the in the course of this claim, I'm inclined to leave this claim as is and using the Part 8 procedure.
I understand, Madam Registrar. However, the facts that the fact of the matter is that in the macro timeline of the dispute between the execution of the lease agreement and the company going into insolvency, and what happened in between with the CFI 059 up until this Part 8 claim, in order to argue these merits, I mean, there's a lot of things that we can do there's a lot of options in a Part 7 claim, where we can at least have in a CMC hearing just before an agreed or disagreed list of issues, and then go on that road of a production of documents, and then argue the case through a statement of defense. A Part 8 claim is too expedited to be able to have standing in defending that claim on Part 8 proceedings.
I don't know if I've misunderstood the nature of the claim, because it seems like we're speaking about two different things. Mr. McCarthy, this claim is for the reimbursement, or can we put it as that, or payment of the assets that the parties were initially in discussions about the sale of these assets from the claimant to the defendant, for some reason, for reasons that,
Yeah.
multiple reasons, that sale did not
Correct.
go through, and therefore the assets remained in the premises of the prior premises of the claimant, the premises that ultimately are owned by the defendant. And at some point in time, the claimant found that the liquidator's lock and seal had been broken, the assets were nowhere to be found. And therefore, the claimant files this claim seeking the reimbursement of these assets that were removed from the claimant's premises or from the defendant's premises that ultimately were owned by the claimant. Is there anything else in this claim?
That's essentially the crux of it, Madame.
Okay. Mr. Senwan, can you tell me if any of those facts are disputed?
Basically,
Sorry, Mr. Devan, because it's not that the assets to be found. It's more the point that the assets are there and being used by a third party.
Okay.
That's the issue. But yes, that's the crux of the argument on the dispute that we say isn't disputed.
Mr. Senwan?
yeah, thank you, Madam Registrar. The fact that the assets are still located in premises, it's not a disputed fact, has just been confirmed by a witness statement by Mr. Tharwat Qubaisi. However, whether the claimant should be reimbursed or be surrendered these assets to the liquidator, this is a disputed fact. I mean, on the basis of the defendant having these assets located in the premises, and whether the liquidator's rejection of the proof of debt is actually stands or not, the facts surrounding that decision and the way whether these assets should be surrendered or be reimbursed, and whether there is damages or not, this is also factually disputed, and we would like to dispute these facts thoroughly through a Part 7 case, respectfully, Your Honor.
I think our position, or our client's position on that, Madame, is that you have the Part 7 avenue. They've had the Part 7 avenue last year. They chose not to take that. They still have that avenue if they wish to make a creditor claim. You can do that on the Part 7. They can do so. They can make the arguments, and we can respond accordingly. Our issue is that we have these assets that we say are not disputed or in the premises, and we need to get a resolution of this issue as soon as possible. It's been 2 years. 2 years since 49 creditors have waited to be paid out and for the company to be wound up. If this goes down a Part 7 route, we're looking at another 2 years, 4 or 5 years of a company being, not to say the least, but permanently put into liquidation where it hasn't been able to liquidate. That's significant prejudice, not only to our client and his obligations, but also to the creditors of the company. I don't think if this goes down a Part 8 avenue that you prejudice the defendant as such. They still have their right to bring a Part 7 claim under and they can do so under a Part 7 if they feel that there's disputed facts in relation to their creditor claim.
All right, is there anyone who wishes to say something else, or have we managed to air out all the issues?
Nothing from my side, Madame.
Nothing from my side, Madam. Thank you very much.
All right, we'll get back to you with the decision within before the end of the week. That's okay. All right. Thank you very much, gentlemen.
Thank you for your time.
Thank you, Madam.